Okay, Myers and Highway 46 Holdings is next.
May I proceed, Your Honor?
Sir.
Darrell Bloodworth appearing on behalf of Myers, the appellants. This case is back before this court for the second time as a result of Circuit Judge Lawton's order of April 19, 2010, 5 years ago, dismissing most of the Myers claims and cross-claims, most of which were dismissed as a sanction against him. And in the prior appeal before this court ruled three things. Held first, most of the counts in the counterclaim did state a cause of action. There were certain ones that it upheld the dismissal with prejudice. Those are no longer an issue in this case. But for the rest of them, this court said they did state a cause of action. Secondly, that the lower court was in error in holding that the Hackenbergers were improperly joined as parties, and further held that the Hackenbergers' joinder was necessary for complete relief in the case, even on some of the claims that the plaintiff had asserted. And then thirdly, this court remanded to the lower court because Judge Lawton was in error in not holding a Cassell hearing. Now, following a lengthy delay, there was a hearing on October 17 before Judge Mihawk in the case, and on January 2nd, Judge Mihawk entered an order stating that all 6 factors of Cassell were met. And then there was a rehearing. Judge Mihawk confirmed his order, and this appeal ensued. I think it's very important right off the bat to establish that even if this court were to confirm Judge Mihawk's orders, which we suggest would not be the correct ruling, but this would not bring this case to an end. The plaintiffs still have to proceed, and all of the Myers affirmative defenses are still there. It all involves the same body of operative facts that apply to the plaintiff's claims, their defenses, and to the Myers counterclaims. And so, and if it upholds it.
Judge Mihawk missed the boat. I mean, it seems that he did what this court said to do, and that's hold the Cassell hearing. Where did he miss the boat?
He missed the boat in 2 basic ways, Your Honor. Number one, he did not pay sufficient attention to the court's admonition in Cassell that this is the ultimate sanction and should only take place in the most extreme cases. And it certainly is not an extreme case when some of the problem, not all, but some of the problem has been due to errors made by the court below.
The case is in the pleading stage, right?
Well, it is in the pleading stage, but this court's already said they state a cause of action. All we need for the rest of those is an answer in trial to be set.
27 volumes and 5,500 pages.
It is long, Your Honor. I'm not denying that.
That's incredible.
It is, but that is not. But that is not the reason that the case was dismissed.
I think he has said, you know, I'm going to give you one more chance.
No, if I may correct, what happened was there was an order entered by Judge Smith, who had the case previously. On September 16, Judge Smith entered an order dismissing for failure to state a cause of action. And he said, I'll give you one more opportunity to state a cause of action. He also addressed the issue of prolixity and said, they've asked me to dismiss. I'm not going to dismiss on that basis. So there was no warning to Mr. Benitez that if he didn't shorten this pleading up, that he was going to have the ultimate sanction. And in the same order that Judge Smith entered, he erred by saying they couldn't join the Hackenbergers. That error then was repeated then by Judge Lawton, as this court has already found. And the plaintiff can't even go forward with all of their claims without the Hackenbergers in the case. So I think Judge Mihawk was an error there. Secondly, Judge Mihawk, although he said he doesn't believe there's any other remedy, there are other remedies. He didn't say what they were, and something less than dismissing the client's claims for the lawyer's mistake should be found. And I think that would be consistent with the Supreme Court's ruling.
Yes, what do you want, if we reverse, what would we do? Send it back, say the Sixth Amended counterclaim's okay, or?
Well, this court has already said that most of the counts state a cause of action. You send it back and say the defendant should provide an answer. It can be set for trial, and if the court finds some lesser sanction than dismissal with prejudice, the court can determine that. And this case could be tried before the end of the year. So I think that's the way it should go.
The complaint is, the grievance is, it's too long, right? I mean, we already said
Prolixity is, that's what, that's...
So that would be, if it's too long, that means that it's got redundancies or irrelevancies. I can't think of anything else. Redundancies or irrelevancies.
Immaterial thing.
Immaterial things. Is there any case out there where a court has ever been able to just dismiss a case because it had irrelevant or immaterial allegations in it?
I'm not aware of any specifically for that, and in fact, in the Rolling case, where there was a warning given, this thing is too long, if you don't shorten it, we're going to dismiss you with prejudice the next time. It went up, and in that one, the second DCA said, that's even with the warning, that's just not sufficient to give the ultimate sanction here.
I mean, you have the authority, the court has the authority to strike anything that's immaterial and irrelevant, right, or redundant.
Well, they do, Your Honor, and I would point out, since this court has upheld a large number of the counts, much of that is already gone anyway. And that's the law of the case in this point. So you're only left with the counts that this court did not sustain dismissal with prejudice on. So for the remainder of it, it should go back. There should be an answer filed. The case should go to trial, and it'll shake out when the evidence is sought to be entered. And I think that would be the appropriate range. Now, I can go through the issues here in the factors, but I think the key factors here are that order by Judge Mihawk and his reconfirming that does not comply with Cosell, and secondly, a lesser remedy should be found. This case should be tried on the merits, not on the basis of Mr. Benitez's failure to strictly adhere to Rule 1.110.
On the Cosell test, there's those 6 factors the court's supposed to look at. He doesn't have to find all 6 factors, right? He has to look at the 6 factors and then weigh the totality. Is that correct?
That is my understanding of the law, yes, sir.
So if we were to decide, for example, that the trial judge came out the wrong way on one of the 6 factors, would the result be a reversal for him to do a new Cosell test, or would we get to the ultimate merits of deciding that it doesn't meet the Cosell test?
I think this court has the authority and to send directions to the court, as the court did in Rolling, and send it back, and citing the Supreme Court in Cosell, and even in the Ham case later decided, where they said one issue was not the sole one, but they repeated the fact, the ultimate sanction of dismissal we do not favor, and it should be only the most extreme cases. So for those reasons, I think this court should send it back, say find another remedy, send this case to trial. The answer should be filed within 20 days and get this on the court schedule. Now, with regard to the factors themselves, whether the attorney's disobedience was willful, remember, this must relate, the disobedience must relate to the reason for the dismissal. The reason for the dismissal here was prolixity. He had not been warned on prolixity previously, and so even if he has not complied with the rules strictly, there was no intentional intent to disobey the court, and because the ultimate sanction is supposed to be for a case in which a lawyer or the client intentionally disobeys court orders, not necessarily court rules. There'd be a whole lot more cases dismissed if every time a lawyer disobeyed a rule, but it's a court order. Judge Smith, as I pointed out before, had pointed out this prolixity, but he was not going to dismiss, but then Judge Lawton did go ahead and dismiss. This court has already found that most of it was for prolixity, and he didn't hold a Cosell hearing. That's what's led us up to today. One of the things that, of course, they've talked about, too, is Did he intend to disobey? Keep in mind, one of the reasons he kept getting longer is his complaints kept getting dismissed for reasons for which they should not have been dismissed, as this court has already found, because both Judge Smith and Judge Lawton were in error in dismissing the Hackenbergers from the case. So whether the attorney's disobedience was willful, I think you have to look at least in part at the subjective belief of the lawyer to have the intent. Mr. Benitez has repeatedly said he had no intent to disobey any order of the court. He was concerned about whether he was stating a cause of action. They had been in error, as this court ultimately found, but he was trying to be sure he stated a cause of action. The complaint was long, and so here we are. But without a warning and without a specific intent on his part, that element of Cozell has not been met. Secondly, whether the attorney has been previously sanctioned. The reason for the sanction must be related to the reason for the sanction. In other words, it must be something related to pleadings. He was never sanctioned for pleading. Now, Judge Mihawk, on his order for reconsideration, said, well, any dismissal of a pleading, even without prejudice, is a form of sanction. I just don't think there's any good precedent for that. But secondly, that does not comply with the court's admonition in Cozell, because in Cozell, they're saying this is the ultimate sanction, and to say that, well, any dismissal meets that is setting a bar far too low here to carry out the intent of the court in Cozell. Judge Mihawk's order states in a footnote that Mr. Benitez was later sanctioned, and he was, but not for a pleading violation, which is the reason for the dismissal. And the sanction, or the prior sanction, must be related to the reason for the dismissal. It can't be for something else. And in fact, I'm not quite sure why I even cited that in a footnote, because that does not support his point. Third, whether the client was personally involved in the disobedience with regard to the pleadings. In his original order, Judge Mihawk said the Myers did not participate in the disobedience. In his order on reconsideration, without any new evidence being taken, Judge Mihawk said, it is not clear how much involvement the Myers have had in the drafting of the pleading, but went on to say the Myers stood by for 6 years, and therefore this Cozell factor is met. Well, I don't believe that's a sufficient evidentiary basis, but let me point out, when Judge Lawton entered his order on April 19, 2010, this case was only 2 years old. I mean, which is, you like to get them to trial by then, but it's not unprecedented by any means that a case be around for 2 years and still in the pleadings. Everything that has happened since then comes out of Judge Lawton's order, and Judge Smith's order before that, where they were in error, and then Judge Lawton was also in error in not holding the Cozell hearing then. Had they not made those mistakes, and had the Cozell hearing been taking place then, presumably this case would have been tried by now. So to attribute all of that to the Myers is just not supported by the record. And then whether the client was personally involved in disobedience, the issue of pleadings is uniquely a responsibility of the lawyer.
No evidence that they're lawyers, these people, right?
They had none. They testified at trial. They didn't even review these before they were filed, so that element was not made. Then whether the delay prejudices the opposing party, as I pointed out, much of the delay, the last 5 years, have arisen out of Judge Lawton's order and the errors that were there and the time it's taken. That simply cannot be, all of this delay cannot be laid at the feet of the Myers. On the plaintiff's side and on the Hackenberger side, they've had a change of counsel. There have been other things going, and they have not aggressively tried to push this case toward trial either. So to say that all of this is the fault of the Myers is simply unsupported by the record. The fifth element is whether the attorney offered reasonable justification for his noncompliance, why the pleading was too long. Well, Mr. Benitez said that he understood fully that Judge Smith had held that the Myers claims failed to state a cause of action. He disagreed with that, and ultimately this court disagreed also with regard to joinder of parties. Judge Smith's order wasn't appealed, but Judge Lawton's was, who ruled the same way. He did not understand that prolixity was a problem that could lead to this ultimate sanction. Had Judge Smith warned him that prolixity could result, well then that might have some credence, but he did not. Under these circumstances, I believe that Mr. Benitez's justification is reasonable. And then whether the delay created significant problems of judicial administration, as I pointed out, this case has got to be tried. It's got to be tried on the same facts, and it will not take much longer, if any, to try the counterclaims at the same time that the affirmative defenses and the plaintiff's claims. So we recommend strongly that this case be sent back to the trial court with instructions to find some lesser sanction, require the appellees to file answers, and get this case on the trial docket. This case should be decided on the merits, not on the basis of a sanction against the Myers counsel. I'd like to reserve the last 4 minutes.
4 minutes, Mr. Woodworth.
Counsel, may it please the court. Damon Chase.
Are you both going to argue, Mr. Chase?
Sir?
Are you and counsel both going to argue, or you take?
Yes, sir, I was going to address that.
Okay,
Mr. Klein is here on behalf of Glenda Hackenberger, and I believe we have 20 minutes. We'd split up. I'll take 10, and he'll take 10.
10 and 10, okay.
Yes,
I shouldn't have interrupted you, and I didn't start the clock yet, so
I appreciate that.
let's start it.
So I got that free. Damon Chase with Chase Freeman on behalf of Highway 46 and Don Hackenberger. There was, one of the questions that was just raised was, is there any support for dismissal because of prolixity? And the response was, we couldn't find any, but of course there was. There's Judge Mihawk cited in his order, especially the order on reconsideration, he cited Lutheran, which is a third DCA case, that dismissed with prejudice for failure to streamline a long-winded complaint. Kozich was a fourth DCA case that also dismissed with prejudice for failure to reduce the size of the complaint. This court in Myers 1 cited Samuels as holding that the continued failure to file pleadings in conformity with the Rule 1.110, which is the short, concise statement, can be cause for dismissal with prejudice. And in fact, this court went on to say that upon remand to conduct a Cozell hearing, the court may find that the failure to conform with Rule 1.110 is sufficient for dismissal with prejudice. You just have to go through the Cozell factors. And so...
How about the judge's finding on the involvement of the clients? They're not involved in drafting pleadings, or...
There was testimony about their awareness and about them being aware of the facts, and in the first order that Judge Mihawk rendered, he talked about there was, but there wasn't sufficient for him that he didn't feel comfortable saying, okay, they were involved. But in the second, and the petitioners or the appellants requested the reconsideration. Upon reconsideration, Judge Mihawk considered some of the other cases that are out there that hold, particularly Rose, and also Rawling, again, cited to Rose, that clients can't just sit by and then claim ignorance at the end for years as things go on and as those pleadings are being filed and improperly being filed.
Now, did the orders, now the client would have seen the orders, did the orders caution counsel about the prolixity of the pleading, or did they just say dismiss?
Judge Smith absolutely did. It said that it's unnecessarily long, and it doesn't go in, it doesn't say, it doesn't break down, and it properly doesn't break down, this is what's wrong with your complaint, and this is what you need to fix, because that's not a judge's job. That's the lawyer's job, is to understand that. But he did say, it's unnecessarily long. He said also, I'm not dismissing just because of that, but oh, by the way, it's unnecessarily long, and I'll give you one more chance, and you need to fix the problems with your complaint. that's a warning. And clearly, and we talked about, the sanction, it is an extreme sanction about dismissing with prejudice, but it's an extreme violation. You talked about the length of this complaint. If I'm driving 85 miles an hour down Highway 95, I'm going to get a ticket because I violated, and that's a good sanction. But if I'm going 180 miles an hour down Highway 95, I'm going to get thrown in jail because that's an extreme violation. When you start coming into court with a 200-some-odd page complaint and then plus exhibits where you have piles and they dismiss it and say, this is unnecessarily long, and then you come back with a longer complaint, so I get pulled over for driving 100, and then I get a warning and I go, but they let me go, and then I get pulled over down the road for going 120, that's a problem. And so the sanction fits the crime in this case, and there was a warning, and it's not only the case law suggests in Ham, which is the most, I think, dispositive on interpreting Cozell, cites to Mercer and talks about, it's an abuse of discretion standard, we all agree that, but then it talks about that, and the courts apply a reasonableness test, and the court says in Ham, citing Mercer, that reasonableness is determined if reasonable persons can differ, then the decision was reasonable, and therefore the lower court's order should not be disturbed. In this case, 3 judges, good judges in Orange County, dismissed these pleadings. Judge Smith dismissed it, Judge Lawson dismissed it with prejudice, and then Judge Mihawk came in and dismissed it with prejudice twice. And so you have reasonable people, at least at the lower court level, saying that this is a problem, and they are the ones who are there charged with administering justice, and they're seeing and they're having to deal with this elephantine complaint over and over again. And they're saying, this is what you have to do, and yet Mr. Benitez, respectfully, just kept doing what Mr. Benitez has been doing.
The previous sanction that the trial court found under the Cozell factor.
Under the Cozell factors, he cited the cases that talk about dismissal without prejudice as a sanction. Counsel had argued that he couldn't find authority for that, but there absolutely is. The World of Wheels is one cited by the court, and what it says is, and there are a bunch of cases, and reading this stuff, getting ready, when the courts are talking about Cozell and consider a lesser sanction, they talk about a lesser sanction including a fine, contempt, or dismissal without prejudice. And so if the courts are saying that dismissal without prejudice is a sanction that you can consider, then of course dismissal without prejudice is a sanction, and in this case was applied. And so he had been previously sanctioned for the same thing.
So any time that you have a case that's gotten to a first amended complaint because a motion to dismiss was granted, you're going to meet that Cozell factor because that's a previous sanction?
No, sir, I wouldn't say that. I think that the cases, and it's all over the place about, there's every case generally that addresses how many times can you amend before it's time, before you've exhausted your right to continue to amend. And they say there's no magic number. They say you should at least get 3, and then there's one of the cases that is in the record here, I believe it is Rowling, that says it could be between 4 and 10, but somewhere in there you can say that is being too many.
So if you filed 4 amended complaints, does that mean you've been sanctioned 4 times because the first?
I think that if you've been dismissed without prejudice, more than...
Those is a sanction?
Yes, sir. And each time I would submit that it gets a little more severe. The first time I get pulled over for speeding, I might get a warning. The second time, I'm going to get a ticket. And if I start accumulating these points...
For failure to state a cause of action because I left out an element that all conditions preceding were met. So I have to file an amended complaint to throw that paragraph in. Have I been sanctioned because I didn't put it in the first complaint?
I think according to the case law and determining whether or not that a dismissal without prejudice is a form of sanction, yes, I think it's not something that you're going to get in trouble and we've got to write a letter to the bar over, but it's a form of sanction according to the case law, according to the courts that say...
Now, is that dismissal of the action without prejudice or dismissal of a count without prejudice in the sanction context? If the sanctions are, I can fine you, I can do this, or I can dismiss your action without prejudice and make you refile, right? The sanction isn't going to be, I'm just dismissing the count and let you refile because you've already done that.
I think dismissing the action to where you close the file and they have to refile, that's a significant sanction.
That is the basis to define what a sanction is.
No, sir, I don't think that the courts that talk about dismissal without prejudice as a lesser sanction. I don't think that that's what they're saying. I think that they're talking about dismissing the complaint in the terms of...
So the lesser sanction would be, I would dismiss it without prejudice and let you refile it in the same lawsuit?
That's what...
Another time?
That's how
How's that a sanction?
I believe that that's what the cases say, and because it's a dismissal. You're saying that you've done something incorrectly. You, counselor, have done something incorrectly. You failed to do something properly, and so go back and do it again. And that's what, and Judge Mihawk agreed, and he said that, and he cites the cases. The cases say that, and I don't think that we can read other words into the cases. They say that a dismissal without prejudice is a lesser form of sanction that is available to a trial court in these determinations. And that's what Judge Mihawk cited, respectfully. So we have, what's interesting is the cases that were before, and even the JACQUELINE case and the Scarvin case that were out of the 5th DCA talk about that there's a necessity to make expressed written findings as to the elements, and clearly Judge Mihawk has satisfied that. He expressly found willfulness. A big deal is that you have to find willfulness, and he expressly found that. Another interesting thing, that if we're looking at the precedent, in this case, in JACQUELINE, and even in Ham, where they remanded to the trial court to conduct a Cozell hearing, they told the trial court, oh, by the way, we've reviewed the record, and it doesn't look like you have enough to dismiss with prejudice, so we're remanding, do your Cozell hearing and figure something out. That's not the case in Myers 1. The Myers 1, which is, I say, identical to Rawling, which just said, go back and perform the Cozell analysis. In Myers 1, it said that you may find that this elephantine complaint is sufficient to dismiss with prejudice. However, you've got to go through and do the Cozell analysis in order to validly dismiss this without prejudice. And that's the words of this court on this case. So respectfully, I have 4 seconds left, and I would tender the rest of my time to Mr. Klein.
All right, thank you, sir.
May it please the court. Jason Klein of Latham, Sugar, and Bodine, Orlando, on behalf of appellee Glenda Hackenberger. I'd like to touch on a couple of points that the court raised in questioning Mr. Chase. First, regarding client involvement that Judge Palmer asked. In Judge Mihawk's, at the Cozell hearing, Judge Mihawk brought this issue up and stated that it was a matter of common sense. He states, it seems to me that common sense would indicate that an attorney working for a client is not going to make up facts out of thin air. Those facts have to come from somewhere, and most of the cases I'm aware of, those facts usually come from the clients by stating in a fragmented statement, yeah, and I would agree, Your Honor. The issue of client involvement also goes back to the fact that in this case, after Judge Smith issued his 2009 ruling that said that the 206-page counterclaim was unnecessarily long, and I'm going to give you a final opportunity. There's the warning. It's unnecessarily long. I'm not going to dismiss it for prolixity. I'm going to take, as Judge Smith says, a cautious approach, give you a final opportunity to amend this. And what does Mr. Benitez do? He goes back and adds 24 more pages to an already unnecessarily long complaint, brings it before, recuses Judge Smith, has Judge Smith recused, and uses an affidavit of the Myers, again, showing client involvement. The Myers filed an affidavit to recuse Judge Smith. The Myers filed an affidavit to recuse Judge Lawton. Every time there was an adverse ruling, this goes into judicial administration, one of the factors of Cozell. They have recused a judge. They've asked the judge to step aside because they don't agree with the ruling. There's clear client involvement. Judge Lawton didn't see it at the time of when he made his ruling, but certainly Judge Mihawk considered the evidence before him at the Cozell hearing and addressed that, and it is a matter of common sense. A 36-count, 227-page complaint is not pulled out of thin air. Again, getting back to the issue of a lesser sanction, appellant's counsel pointed out that one of the two, he stated there were two problems with Judge Mihawk's dismissing this case. One was that he missed the boat and that he didn't realize this was the ultimate sanction, the penultimate sanction of dismissing a pleading, which would ultimately punish a client. That's not true, because in the order of reconsideration, which is before this court, those are the two orders, the dismissal and the reconsideration in March of 2014, Judge Mihawk at page 8 states in paragraph 11, in conclusion, the court is mindful that if a sanction less severe than dismissal with prejudice appears to be a viable alternative, then the court should employ such an alternative. And this is what's important, and he cites Kozel. At the hearing for reconsideration, counsel for the Myers did not suggest any sanction less severe than dismissal for this court to consider. That's key. They didn't propose any less severe sanction at the motion for reconsideration. Nevertheless, this court has entertained some alternatives to dismissal. This is Judge Mihawk addressing that issue of Kozel. Should there be a lesser sanction available? Should we do a lesser sanction such as a dismissal without prejudice? And as Judge Palmer was just asking Mr. Chase about a lesser sanction, this court in Wells Fargo versus Stoller, a 2013 case, and I have the site, it's a 115 Southern 3rd 1105, there were discovery abuses in that case, to be sure. It wasn't on point in terms of a pleading violation. There were discovery sanctions, and the lower court dismissed with prejudice. This court said a lesser sanction, such as a dismissal without prejudice, should have been considered. We already have 2 dismissals without prejudice in this case. January of 2009, Judge Smith.
Isn't the most important Kozel factor whether or not the client is to blame for any of this?
I would say that it's one of the factors. I would say that it is an important factor, Your Honor.
Obviously, one of the factors.
So, absolutely, and it is a very important factor.
Yeah.
Yes, sir, I would agree, because at the end of the day, and the Florida Supreme Court's been abundantly clear, at the end of the day, it's the client that's going to be punished.
Right.
They haven't held that it can't happen. They haven't said in cases where we simply will never dismiss a case with prejudice.
No, but I mean, you get into things like discovery, you're talking about things that the client is culpable for. Here, we're talking about something that is, as Mr. Budworth said, really uniquely within the province of the expertise of the attorney. Unless you have a client that is peculiarly sophisticated, pleading is something that only the lawyer knows how to do, right?
That is true. You're correct, Your Honor.
I mean, what did the judge rely on in making that finding that the Myers should be held culpable for this kind of deficiency?
At the hearing on the Kozel hearing, I asked the Myers under oath, they were there, and I cross-examined them about whether or not their involvement. It was met with, as to be expected, several objections that it was going to get into the attorney-client privilege, understandably so. I did ask them if they'd received the pleadings. I think they'd said they couldn't recall. There were issues regarding this, and after we had a back-and-forth banter between counsel getting into attorney-client privilege, Judge Mihawk, for lack of a better term, took judicial notice and said it's a matter of common sense that this elephantine pleading that rose to the level of 227 pages shows client involvement. The fact that the Myers filed affidavits in this case prior to Judge Lawton dismissing it shows client involvement. This is not a case where the client sat by idly and had no involvement in the case whatsoever. Filing affidavits, recusing judges, and getting a complaint that's not a couple of pages long, it's 227 pages long, it stands to reason that the clients were involved. The fact that they wouldn't testify under oath that they were directly involved with signing and dotting the I's and coming up with the language for the complaint, I don't think necessarily shows they were not involved. I think the record reflects that. I think Judge Mihawk was within, again, abuse of discretion standard. It's reasonable to look at a pleading with his experience, with the testimony before him, with the argument back and forth between myself and Mr. Benitez about attorney-client privilege, to state it's common sense that they had to have some involvement. As Judge Jacobus pointed out, this is there's 17 volumes and 5,000 pages of documents, and 27 volumes, 5,000 pages, and we're still in the pleading stage. We are still in the pleading stage after 7 years, 3 appeals, this is being the 3rd, 5 judges, 2 who have been recused, 2 or 3 have been reassigned. So to say there's no client involvement.
Looking at the culpability of the client here, the culpability of the client is based on the assumption that they looked at the pleadings and that they should have known that the pleadings were improper, that there was a non-compliance with the rules, and they should have fired their lawyer and got somebody that was competent.
I would agree with that in part, Your Honor. I would think that at some point...
They should be sanctioned by losing the right to go forward with their appeal. That's the proper sanction for that particular crime, right?
I would agree with that, Your Honor, yes.
I'm not saying I agree with it, I'm asking you.
I understand. I think when you look at the totality of the circumstances, if it was just the second or third pleading that we're talking about, and we had little client involvement, no affidavits, no recusals, I think those are key, and I think we have to not forget the fact that looking at the pleading, that it grew and grew and grew and grew and grew, and that the judge at the lower court, Judge Mihawk, said it's common sense that they had to have involvement, and the fact that we couldn't get into their specific involvement because of attorney-client privilege, which
What was the language in the order that talked about its verbosity?
I'm sorry?
What was the language? What did the judge put in the order that talked about its prolixity or...
Judge Lawton?
Any of the orders. I mean, along the way, what gives the clients notice that the real problem here is that, you know, that the complaint is too long?
Sure. Judge Lawton's order, this was from April 19, 2010. This is Judge Lawton's dismissal. The pleading is repetitive, disorganized, and disjointed. It is so replete with superfluous factual allegations and rambling legal conclusions that it is barely comprehensible. Florida Rule Civil Procedure 1.110 requires that a claim for relief state a cause of action and contain a short, plain statement of fact, short, plain statement of the ultimate facts showing the pleader is entitled to relief. The prolix nature of the second amended counterclaim makes it violative of this rule. And in the 50s, this court agreed with that, and this court called it an elephantine pleading, and that was back in 2011. Now, do the Myers have a cause of action against Mr. Benitez for malpractice? I don't know, and certainly that's not what we're trying to bring before the court. They might, and cases that have talked about and discussed.
You're over time, sir. Thank you very much. All right, you got 4 minutes left, Mr. Bloodworth.
Yes, Your Honor. First point, in response, he said that there are cases where there have been dismissals based upon pleadings. What I hope I said, and I intended to say in my argument, we haven't found a single one where there was not a very clear warning that if you do not clear this up and comply with Rule 1.110, we're going to dismiss with prejudice. There is not a single case we found without that warning.
Sounded kind of clear to me.
They did not. I don't believe those cases where they dismiss, or if they did dismiss, a very, very clear warning was given. We don't have that in this case. The Judge Lawton's order he just quoted, that was the sanction order. There was none before it. The only order before that was Judge Smith's order, and he said the Myers pleading is 203 pages long, and according to counsel for Hackenberger, the exhibits add an additional 249 pages. The court's responsibility to analyze and rules on the parties' arguments does not change based upon the enormity of the Myers pleading. Although the court believes the Myers pleading is unnecessarily long, it declines the invitation by plaintiff Hackenbergers and Daugherty to dismiss these claims on the ground of prolixity. There's no way in the world that the Myers could hear that or read that order and say, my goodness, they're going to dismiss our case if we don't go get a new lawyer. There was a dismissal, and he also said, well, 3 judges have dismissed this complaint, but this court has already found, yes, but they were, at least in part, in significant part, in error in doing that, both on the issue of the joinder of the Hackenbergers and in procedurally going through Cosell before actually entering that order. They talked about, one of the cases he cites is the World of Wheels case, and if I could grab this, The only statement in here is when the appellate court said, "We're reversing the final order of dismissal and remand the cause for further proceedings with leave for the trial court in its discretion to impose lesser sanctions in the case," and he throws in saying, "including a dismissal without prejudice." That is not the same thing as saying that every time you have a dismissal without prejudice, a lawyer's been sanctioned. And in that case, the lawyer failed to file a pretrial stipulation, failed to attend the pretrial conference, and failed to show up for trial. That clearly is the kind of activity that is pretty extreme, but even there, the court says that's not enough to dismiss with prejudice. He talked about the affidavits being filed, which is very telling because this is a dismissal, a sanction for pleading violations. The affidavits that the clients filed, that the Myers filed, had nothing to do with any pleading violations. And clearly, the Cosell indicates the sanction must relate, the prior sanction or involvement must relate to the disobedience. The disobedience, supposedly here, is filing prolix pleadings once being warned about it. And the client must be involved in the disobedience. It's not enough just to say that the client gave facts to the lawyer. The client's got to do that in every case. The client must be involved in the disobedience regarding the sanction, which is dismissal because of prolixity, and there's absolutely no evidence in the record that they did so. Again, this case should be decided on the merits, not upon what the lawyer did or did not do. Thank you, Your Honor.
All right, thank you.